What I want to start off with is really an overview of the legal tensions between law and faith and parental rights, and so I've entitled this talk Where Faith Meets the Law, Child Welfare Laws and the First Amendment. I'll talk a little bit about some of the United States Supreme Court principles and then get into a little discussion of some of the state cases that have actually dealt with religious child maltreatment. Some of the United States Supreme Court cases that really have given us the legal parameters by which we discuss this issue don't involve child maltreatment per se, but they are cited in virtually every single reported court decision on child maltreatment. We start with the assumption, both as parents and in the law, that parents love their children and they want to do what's the best thing for them. And to people of faith, you know, children are considered to be a gift from God. And we have obligations to nurture and care for that gift that God has given us. We assume also that parents know best how to rear their children. And we assume that parents' love for their children is child-focused and benign. Now, these assumptions aren't always borne out, in fact, and certainly aren't always borne out in the individual relationships that some children have with their own parents. From the child's perspective, often the teaching in our faith communities analogizes God to a parent, to a father. And so children's view of God often is developed through the lens of how they're treated in their own families and by their own fathers. And the language that they hear from people in their faith communities is often, again, heard through the context of and are kind of triggered by their relationships in their own homes and in their own communities. If God is supposed to be like my father, and my father is abusive, and my faith community is abusive to me, then that is going to screw up my relationship with God. Now, parents generally, maybe there are some free thinkers who philosophically are opposed to that. I think probably not to the degree that they think they are. Generally, parents want their children to accept their values. And that may be they want their children to be free thinkers. And if their children are not, they're upset that their children have not accepted their values as being free thinkers. And people of faith want their children to be people of faith. People in the Tea Party don't want their children to be flaming liberal Democrats. And I can tell you, as a flaming liberal Democrat, I would have been horrified if my child had been a member of the Tea Party. And was pretty scandalized when my grandson, who just turned 18, and I asked him, did he vote in the Virginia election, and was he registered to vote, said, I didn't vote, and I'm not really interested in all of that stuff. So I'm going to have a little more talk with him, because even though he is not my child, I want my child to understand the civic responsibility of voting, even if he were to vote contrary to my own politics. So for people of faith, you know, parents feel that they have a God-given responsibility to raise their children in their faith. They think that, you know, they're doing something good for their children. Most parents are not just malevolent, sadistic people who have children and just want to make their lives miserable and torture them. They may make their lives miserable and torture them, and probably every teenager who lives thinks that that's what their parents are doing. It's the sole, you know, job and joy of their parents to make their lives miserable. But ordinarily, you know, we think that we're doing what the right thing is and that we're loving our children. And so for people of faith, raising our children is something that we do to be pleasing to God, to fulfill our obligations as parents that we believe God has given us to these children that have been entrusted to us. but also that ultimately this is going to be good for the children. Whether it's going to be good for the children here on earth or in some afterlife, you know, that is the subjective goal. It's also how faith gets passed on from generation to generation. And in most faith traditions, there are injunctions to tell your children about the faith. You know, why do Jews have the 4 questions at Passover? Because the children have to understand what, you know, why are we doing these things now? What is the history of our people, and what does God want? So those are all kind of the basic things that we look at in thinking about parents' rights. Now, we are a heterogeneous society. There was a book written some years ago to define what is child abuse, what is neglect, what is good parenting. And part of that was to look at, when we look at studies that are done by psychologists, for example, are we measuring the same things? And it was very interesting because there really wasn't, I mean, certainly there was some level that most people in this country would accept as child abuse. I think everybody would think that live sacrifices of your child, you know, taking your child to some faith place and you know, slitting their neck and killing them, I think there's probably consensus in this country that that's child abuse. There is probably consensus that breaking bones is child abuse. Scalding a child as part of their potty training, I think there's pretty broad consensus that that's abuse. But there is a whole huge area where there is not consensus. There are the people who believe that any kind of corporal punishment is intrinsically abusive. And if you're not allowed to go to some third party and smack them, you shouldn't be able to go and smack your own child and get away with what would be considered an assault or a battery if you did it on anybody other than your own child. And yet there are people who believe that they are scripturally required to use corporal discipline on their children, and that that is good parenting. And I would dare say most people in this country over the age of, say, 60 were probably disciplined at some point through some form of corporal punishment. Where you draw the line between the one swat to get somebody's attention through multiple layers of clothing and people getting beaten, that is an area about which we do not have unanimity. There may be a growing consensus against the use of corporal punishment, but we certainly, you know, are not there. Legislators have not said that there is not the, quote, reasonable discipline exception for parents to use corporal punishment. We're starting to get there in terms of schools using punishment. But we don't necessarily agree on what is good parenting, what is child abuse, what is child neglect. And the law is usually not very forward-thinking. The law usually doesn't establish new things. It kind of trails behind where there is a certain degree of consensus in the community. And so courts have recognized that the parents have a constitutionally protected right to raise their children without undue influence. And there are only certain circumstances under which you're able to, as the state, intervene and come between that parent's way of raising their child. And so I'm going to look at a few court cases. And by the way, if you haven't already sent Jan an email, I have the full text of all of these cases. I have the handout sheet for my PowerPoint presentation and some other resources available on a Dropbox that you're welcome to take. But I just want to highlight a few of these cases and a few of the things that have been said in these cases, because they are, as I mentioned, cited in virtually every reported court decision talking about these issues. The first one is Meyer versus Nebraska, and I'm going to go through these chronologically. This was decided in 1923, and there was a law in the state of Nebraska that said prior to a child reaching a certain age, you could not teach anything in a foreign language. And the purpose of this law was to assimilate immigrant children into learning English. And there was a teacher at the Zion parochial school who was convicted criminally of unlawfully teaching a child under the age, who was 10 years old and who had not successfully completed the 8th grade. That was the cutoff. And this child was only 10 years old, and he was taught the subject of reading in the German language. And so Mr. Meyer was convicted of doing that. And the court overturned that, and in doing so, one of the things it talked about under the 14th Amendment liberty issue, liberty right, was, it says, while this court has not attempted to define with exactness the liberty thus granted by the 14th Amendment, the term has received much consideration, and some of the included things have been definitely stated. And so it lists a number of them. And then it includes, and this phrase, if you've got a case dealing with anything with parental rights, I guarantee you this phrase is going to be in that decision, and you're going to cite to it. The freedom to marry, establish a home, and bring up children to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. So this was the first time the United States Supreme Court really articulated the right to establish a home and bring up children. We next come to Pierce versus the Society of Sisters in the Holy Names of Jesus and Mary. In this case, Oregon had a law that basically required everybody to go to a public school. And the Catholic Church had long been known for maintaining parochial schools, and they objected that, one, this interfered with the church's right to carry on a business enterprise and a part of its ministry to teach its children, and that it also interfered with the parents' fundamental constitutional right. And the Supreme Court said in that case, the child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. And that language is cited by a number of cases as well. Then we come to 1944, Prince versus Massachusetts. And this is the closest to the religious child abuse cases that we come to. This was a case where a child was handing out literature for the Jehovah's Witnesses. And the question was, one, this is a dangerous activity to be on the highway, at night, handing out literature, and it might interfere with child labor laws. And here are, and I'm going to quote quite a few passages from this case. Again, these are oft cited. I think I have a slide that cites part of this as well. The Supreme Court says, it is cardinal with us that the custody, care, and nurture of the child reside first in the parents, whose primary function and freedom include preparations for obligations the state can neither supply nor hinder. And it cites to Pierce versus Society of Sisters. And it is in recognition of this that these decisions have respected the private realm of family life, which the state cannot enter. But the family itself is not beyond regulation in the public interest as against claims of religious liberty. And neither rights of religion nor rights of parenthood are beyond limitation. acting to guard the general interest in youth's well-being, the state as parens patriae, and I'll talk about that doctrine in a minute, may restrict the parent's control by requiring school attendance, regulating or prohibiting child labor, and in many other ways. Its authority is not nullified merely because the parent grounds his claim to control the child's course of conduct on religion or conscience. Thus, he cannot claim freedom from compulsory vaccination for the child more than for himself on religious grounds. The right to practice religion freely does not include liberty to expose the community or the child to communicable disease, or the latter to ill health or death. The catalog need not be lengthened. It is sufficient to show, what indeed appellant hardly disputes, that the state has a wide range of power for limiting parental freedom and authority in things affecting the child's welfare, and that this includes, to some extent, matters of conscience and religious conviction. And then they said the state's authority over children's activities is broader than over like actions of adults, and what may be wholly permissible for adults, therefore, may not be so for children, either with or without the parent's presence, because this child was distributing the Jehovah's Witness literature with the parent, actually present. And this is probably the most quoted line in all child maltreatment cases. Parents may be free to become martyrs themselves, but it does not follow that they are free in identical circumstances to make martyrs of their children before they have reached the age of full and legal discretion, when they can make that choice for themselves. And they ended by saying, we neither lay the foundation for any, that is, every state intervention in the indoctrination and participation of children in religion, which may be done in the name of their health and welfare, nor give warrant for every limitation on their religious training and activities. The religious training and indoctrination of children may be accomplished in many ways, some of which, as we have noted, have received constitutional protection through decisions of this court. These and all others, except the public proclaiming of religion on the streets, if this may be taken as either training or indoctrination of the proclaimer, remain unaffected by the decision. And the decision was that the state could regulate and say that the child could not distribute this literature on the streets. The next case was 1972, Wisconsin versus Yoder, which involved the Old Order Amish and an Amish Mennonite group who wanted to, according to their religion and traditions, stop the formal public school education of children once they'd completed 8th grade. Their education within the Amish tradition would continue basically as apprenticeship within the community, laboring, farming, doing whatever they were going to do. And Wisconsin had a law that mandated education, I believe, till the child was 16. And the Supreme Court said, a state's interest in universal education, however highly we rank it, is not totally free from a balancing process when it impinges on fundamental rights and interests, such as those specifically protected by the Free Exercise Clause of the First Amendment, and the traditional interest of parents with respect to the religious upbringing of their children, so long as they, in the words of Pierce versus Society of Sisters, prepare them for additional obligations. And the court found that in the Amish way of life, and this is assuming that the children would then elect to stay Amish, that an 8th grade education was sufficient. And the court did not address the possible ramifications of a child who may at some point later decide to leave the community and go out in the world with only an 8th grade education. The court said, our holding today in no degree depends on the assertion of the religious interest of the child as contrasted with that of the parents. It is the parents who are subject to prosecution here for failing to cause their children to attend school, and it is their right of free exercise, not that of their children, that must determine Wisconsin's power to impose criminal penalties on the parents. They said it is entirely plain that the act unreasonably interferes with the liberty of parents and guardians to direct the upbringing and education of children under their control. And then talking about the Pierce case, they said, however read, the court's holding in Pierce stands as a charter of the rights of parents to direct the religious upbringing of their children. And when the interests of parenthood are combined with a free exercise claim of nature revealed by this record, more than a reasonable relation to some purpose within the competency of the state is required to sustain the validity of the state's requirement under the First Amendment. To be sure, the power of the state, even when linked to a free exercise claim, may be subject to limitation under Prince if it appears that parental decisions will jeopardize the health or safety of the child or have potential for significant social burdens. So I hope you're getting an idea of this kind of constitutional balancing that the court is going through. Santosky versus Kramer was a case having to do with termination of parental rights and what due process requires. And this case elevated the standard of proof in a termination of parental rights case from the regular civil standard of preponderance of the evidence to the intermediate standard of clear and convincing evidence. That was the holding of Santosky versus Kramer. But they said, in talking about why they were elevating this standard of proof, they said that the standard of proof more strict than a fair preponderance of the evidence is consistent with two state interests at stake in parental rights termination proceedings. The parens patriae interest in preserving and promoting the child's welfare, and the fiscal and administrative interest in reducing costs and burdens of such proceedings. Then we come to the last Supreme Court case I'm going to talk about on this slide, and that is Troxel versus Granville, which was a third-party visitation statute. The state of Washington had an extremely broad third-party rights statute. It wasn't just that grandparents could seek rights if the child was born out of wedlock or one parent had died or the parents were divorced, which was the typical grandparents' rights statute at that time. Rather, it said anybody, basically under any circumstances, had standing. Could be an intact family, the coach down the road, your neighbor under Washington statute could haul you into court to try and get visitation with your children, which was absurd. Justice O'Connor, in her plurality opinion, referred to it as a breathtakingly overbroad statute. Well, for those of us in family law, we had wanted the court to give us some guidance as to whether the correct standard of deciding these third-party cases was the best interests of the child once you had this triggering event, or whether you had to show that the lack of visitation would be detrimental. They didn't do any of that. But they said a couple of things which were so vague as to also be useful in any other kinds of cases referring to parental rights. They said, so long as a parent adequately cares for his or her children, i.e. is fit, there will normally be no reason for the state to inject itself into the private realm of the family to further question the ability of parents to make the best decisions concerning the rearing of that parent's children. And it said the decisional framework employed by the Superior Court directly contravened the traditional presumption that a fit parent will act in the best interests of his or her child. In that respect, the court's presumption failed to provide any protection for Granville's, that was the mother's, fundamental constitutional right to make decisions concerning the rearing of her own daughters. So we're looking at, in that case, a parent being, first of all, assuming that it's an otherwise fit parent, which is important because an abusive parent, can be said to be not a fit parent, that person's opinions on the decisions they're making are entitled to special weight. So we have the parental rights issue deriving from their liberty interest under the 14th Amendment, and the other constitutional right that we have is the free exercise clause of the First Amendment, which applies, even though it talks about Congress, it was incorporated into the Bill of Rights by the 14th Amendment. It says, Congress shall make no law respecting the establishment of a particular religion or prohibiting the free exercise thereof. And a lot of what we're talking about comes under the free exercise of the parents' religious rights to exercise their religion, because certain things are either proscribed by their religion. You can't have blood transfusions, you can't use medicine, things of that nature, or they are directed by the church in terms of certain punishments and disciplinary techniques that they can use. So on the parents' side of the scales of justice and in this balancing act, the parents have two bricks. They got the fundamental parental rights to raise the children how they want, and then they have the free exercise brick. So on the other side of the scale that we're balancing, we have the parens patriae right. This is the right and duty of the state as sovereign to protect the welfare of its citizens. This derived from the Old English common law, where the king basically was said to be the overseeing father of everyone in his realm. And he had the right and the duty to intervene to make sure that the health and the safety of his subjects was advanced and protected. And some of the earliest applications of the parens patriae duty, which are sometimes used, for example, in environmental cases, and you shouldn't have smog, and the reason the state can come in is because of its parens patriae duty. But it's some of the earliest uses of this doctrine in England were to protect children against their, quote, objectionable parents. And so this right is one that has been invoked to protect children from maltreatment by their parents. So that's what gives the right, the court the right to do that. And there are a few cases we've already talked about, Prince, and we've already talked about Santosky versus Kramer, talking about the parens patriae duty. The third case that I have listed here is Bowen versus the American Hospital Association. How many of you remember the baby doe issues, whether you could withdraw medical care from a child who basically was going to die anyway, and the idea was, you know, should this child have to go through a lot of invasive, ultimately futile, life-saving measures to only have, you know, a very short life with not much quality, or whether the parents could say enough is enough. And, you know, I hope all of you have healthcare powers of attorney and advance directives. You know, many adults will have legal documents saying, under certain circumstances, I either do or do not want feeding tubes. I do or do not want to be put on, you know, a breathing machine, and all kinds of things, because, you know, parents or adults want to make those decisions about how much, just because technologically we can do certain things to keep your heart beating and your lungs taking in oxygen, maybe you don't want to have all of those things done. But then how do you apply that to an infant who is not making that decision for himself or herself? I mean, look at the Terry Schiavo case, you know, where the parents of an adult child want to come in and the husband's got a different view. All these kinds of end-of-life issues and quality-of-life issues are discussed, and this is the context of this Bowen versus American Hospital Association. Who gets to make the decision, and is there discrimination against children with certain very severe congenital defects that will mean they're not going to live very long? And the Supreme Court in that case said, in broad outline, state law vests decisional responsibility in the parents in the first instance, subject to review in exceptional cases by the state acting as parens patriae. So again, the idea was that, you know, parents who love this child ought to be able to pull the plug or not plug you in the first place, that's part of their right. So when we look at these cases, we have to balance the parent's autonomy, and I talked about the two bricks on there, the fundamental parents' rights, liberty rights under the 14th Amendment, and their First Amendment right to the free exercise of religion, against the state's parens patriae right and the duty inherent in its sovereignty. I love this proverb. The way I learned it from the translation was, there's a way that seems right to man, but the end thereof is death. And I think really this proverb captures a lot of what religious child maltreatment cases are. That these decisions, in many cases, that parents are making seem right to the parents, but sometimes literally and sometimes figuratively, the end is death. There's something that the Supreme Court hasn't talked a whole lot about, and that is, what about the child's rights? The scales of justice have two plates. Is there a third plate that can be added onto that scale to take care of the rights of children? And children in the United States have not been afforded very many legal rights, especially, and Rita is saying she's going to talk about that. And does the child have an independent right that we need to consider? And there are a couple of scenarios where that may come in. There is the child who agrees with the parents for religious or whatever reason and say, no, I don't want the transfusion, or I don't want this medical care. And then there is the child who disagrees with the parents. And we talk in the law sometimes about the mature minor. And that's not well legally defined either. There is, no specific say, oh, well, at 16 days or 16 years and 3 days, you're mature. Those of us who have had teenagers know that that is not usually the case. As a lawyer, I know with especially my divorce clients that they're 40 and 50 and 60-year-old people who I don't think are mature yet either. And then there are the emancipated minors. And emancipation is an actual legal status where, for most purposes, not the right to drink or the right to vote, but for most purposes you are considered to be legally an adult, free from your parents' oversight. And in those cases, the child is not under the control of the parent, and the child can make whatever the same decisions are. There's one case, though, that Supreme Court case that does talk about the child's right pitted against the parent's right, and I didn't put it on a slide, but that case is Parham, P-A-R-H-A-M versus J.R. And for the lawyers among you or people who want legal citations, it's at 442 U.S. 584. It's a 1979 case. Again, if you go to the Dropbox for my presentation materials, that's in there. That had to do with parents who had their child, quote, voluntarily committed to a mental health facility. It wasn't voluntary on the child's part. The child didn't want to be there. But the parents thought that the child needed to be there. And so the Supreme Court looked at, does a child have any kind of rights independent of the parent to say, I don't want to be in this psychiatric facility? And the court said, our jurisprudence historically has reflected Western civilization concepts of the family as a unit with broad parental authority over minor children. Our cases have consistently followed that course. Our constitutional system long ago rejected any notion that a child is the mere creature of the state, and on the contrary, asserted that parents generally have the right, coupled with the high duty, to recognize and prepare their children for additional obligations. And gee, surprise, surprise, for that proposition, they quote Pierce versus Society of Sisters, Wisconsin versus Yoder, Prince versus Massachusetts, and Meyer versus Nebraska. And they're usually all kind of cited together. Because more than one Supreme Court case looks better in a brief than just one. The law's concept of the family rests on a presumption that parents possess what a child lacks in maturity, experience, and capacity for judgment required for making life's difficult decisions. More importantly, historically, it has recognized that natural bonds of affection lead parents to act in the best interests of their children. As with so many other legal presumptions, experience and reality may rebut what the law accepts as a starting point. The incidence of child neglect and abuse cases attests to this. And there was not, in Parham, there was not any allegation that the parents were abusing the child. And it says that some parents may at times be acting against the interests of their children. So at least the Supreme Court recognizes that not everybody is benign, loving, mature, and making good decisions. And that fact creates a basis for caution, but is hardly a reason to discard wholesale those pages of human experience that teach that parents generally do act in the child's best interests. The statist notion that governmental power should supersede parental authority in all cases because some parents abuse and neglect children is repugnant to the American tradition. Nonetheless, see, even in these decisions, the balance on that scale is going one way and then another. Nonetheless, we have recognized that a state is not without constitutional control over parental decision in dealing with children when their physical or mental health is jeopardized. Moreover, the court recently declared unconstitutional a state statute that granted parents an absolute veto over a minor child's decision to have an abortion. Simply because the decision of a parent is not agreeable to a child, how many of that times has that happened in our own experience, or because it involves risks, does not automatically transfer the power to make that decision from the parents to some agency or officer of the state. The same characterizations can be made for tonsillectomy, appendectomy, or other medical procedure. Most children, even in adolescence, simply are not able to make sound judgments concerning many decisions, including their need for medical care or treatment. Parents can and must make those judgments. And then they say the fact that a child may balk at hospitalization or complain about a parental refusal to provide cosmetic surgery does not diminish the parent's authority to decide what is best for the child. Neither state officials nor federal courts are equipped to review such parental decisions. And then they said, and this is the last quotation I will read from this, in defining the respective rights and prerogatives of the child and parent in the voluntary commitment setting, we conclude that our precedents permit the parents to retain a substantial, if not the dominant role in the decision, absent a finding of abuse or neglect, and that the traditional presumption that the parents act in the best interests of their child should apply. We also conclude, however, that the child's rights and the nature of the commitment decision are such that parents cannot always have absolute and unreviewable discretion to decide whether to have a child institutionalized. They, of course, retain plenary authority to seek such care for their children, subject to a physician's independent examination of the medical decision. And they basically said that there needs to be a neutral fact finder involved, and they go on to talk about some other things that are not really germane to our discussion. But the Supreme Court did, in this case, show that there are some situations where the child's rights, and in this case they found, the stigma of a psychiatric hospitalization, and avoiding that stigma was a liberty interest that the child had, as well as the interest in not being institutionalized. So that is the broad constitutional background of these cases. So child welfare cases may involve a number of different factual scenarios, including physical abuse, sexual abuse, failure to protect, medical neglect, educational neglect, physical neglect, and an abusive environment. And the abusive environment, I will talk about some particular cases where we look at abusive environment, and that can often apply to some of the authoritarian cults and practices where people are in insular communities and they may not be being physically abused, but the whole nature of that community is deemed to be objectionable in some way. Well, what are the interventions, assuming that the state can meet those constitutional principles and the parens patriae, rights and duties of the state outweigh the parents' duties? What can they do? They can order medical treatment. We used to refer to these cases oftentimes in juvenile court as this is a Jehovah's Witness dependency, which meant you didn't think the parents were bad parents or weren't taking care of their children, but the child was in the hospital and needed a transfusion, and the parents wouldn't agree to a transfusion, so Child Protective Services would file an order. I'd be appointed to represent the child. You know, you talk to the child, you talk to the doctor, and then the judge orders that the transfusion take place. The transfusion takes place, the child goes home, the case is dismissed, and CPS is out of your life. So those cases where they just order a particular treatment, the parent doesn't want the child to undergo chemotherapy, the court orders the chemotherapy. When the course of chemotherapy is over, the state gets out of the case. So that is a fairly minimal intrusion. May not be deemed by the parents to be so minimal, but it's a short-lived kind of intrusion into the parent's life. They can order school attendance. For some state, and I tell you, homeschooling has become a very interesting legal issue. And there's a lot of lobbying going on, particularly among various faith-based communities for homeschooling. And oftentimes, because homeschooled children are not seen by the school nurse, there is abuse that is not reported. Sometimes the educational content of the homeschooling is not adequate to adequately educate the children. And so if the court finds that is the case, the court can order the child to attend another school. Again, not seen as minimal by the parents, but a fairly minimal thing. The child continues to live in the household and the parents continue to make other decisions, except for that one area the child is going to a different school. The court can enjoin certain practices or activities. The child cannot go to the snake handling church and be up on the altar handling venomous snakes. They can sit in the back as long as the snakes don't get out, and then you have a much more intrusive intervention, and that is the child is removed from the home, often because the parents refuse to change what they're going to do and indicate that they're not going to change. And I'm telling you right now, you can tell me all you want what to do, and so those children are taken out of the home and placed in foster care. And then, of course, the most intrusive is termination of parental rights. And when I get into the state cases in just a minute, I'll talk about some of these interventions. Some barriers to returning kids once they've been removed in religious child maltreatment cases are, you basically, the state is under federal obligations under the Adoption and Safe Families Act, is required to make efforts to keep the child in the home and to return the child once the child has been removed. And there's some pretty quick time limits. If a child has been in out-of-home care placement for 15 of the last 24 months, then the presumption is you move to termination of parental rights. And one of the big barriers to the parents becoming rehabilitated in the religious child maltreatment context is that rehabilitation generally requires some insight and internalization that you acknowledge that you've done something wrong. And if you don't think you've done anything wrong, if you think that you are right and your practices are correct, then unless you're just manipulative and are going to lie and tell the state whatever they want to hear, you're not going to internalize and be able to show this change, this light bulb moment that is going to let the state feel that your child is now safe being placed back in your home. And if parents are adopting their parenting practices because they believe this is what God is telling them to do, as between, God and you, who am I going to believe and who am I going to follow? As for me and my household, we'll follow the Lord. I would rather do what God wants me to do than, obey some secular law. Luckily, my God isn't telling me to do things that contravene the law, but some people, their view of what God's telling them to do will contravene that. And so how is that parent going to change their behavior to satisfy the child welfare legal system when to do that would be contrary to God? And they will tell this, usually in those cases, they'll be quite open about it and tell you that. I leave this part, and then I'm now going on to my discussion of state cases with what I've already quoted to you from Prince. So where are the cases where the parents are crossing the line? And again, all of these cases, if you haven't already emailed Jan, she'll send you a link and you can download these. The first one I'm going to talk about is South Carolina Department of Social Services versus the father and mother. This was a Court of Appeals, South Carolina Court of Appeals case from 1988 where a 13-year-old surprisingly went out late. She didn't always obey her parents or tell them the truth. How unusual is this? She went to a party at the home of a friend. She lied about where she had been. So her parents felt that they needed to discipline her. The father took off his belt, beat the girl, until she was black and blue, hit her in the face with his hand. She testified that her ears were ringing from about a day from being hit by her father, and the mother was there, knew about it, did not protect the child, and in fact agreed that this was an appropriate level of discipline for this girl, and it was not child abuse, and even if it was child abuse, it was based on the parents' religious convictions, and therefore the state should not intervene. And the court said that corporal punishment is excessive when injuries such as those suffered by the child in this case are intentionally inflicted. Now, the father brought a clergyman in to testify as a witness for the parents, and this clergyman invoked the Bible as the ultimate binding authority. This case is kind of entertaining because it makes a few kind of snarky comments that I at least found to be somewhat entertaining. The mother testified similarly, and they cited Proverbs, "Withhold not correction from the child, for if thou beatest him with the rod, he shall not die." That proverb is cited a lot in religious child maltreatment cases. And in a parenthetical expression that I love, the court says, "Neither, however, subscribe to the more severe punishment commanded for a rebellious child by Deuteronomy. Stone him with stones that he die." So they're saying, if you're going to pick up beat him with a rod, how is that any different than, stone him with stones? And the court said the mother and father may know the Bible, but they misunderstand the Bill of Rights. They then say the First Amendment embraces two concepts, the freedom to believe and the freedom to act. The first is absolute. You can believe whatever you want. It can be malevolent. The court isn't going to do anything about what you believe. But as soon as you take an action, that is not absolute. The court... You've got 10 minutes. So okay. The court cannot regulate what people believe, but the law can regulate how people act, even if how they act is based on what they believe. If the law were otherwise, a fundamental Mormon could have multiple wives, a Jehovah's Witness could withhold medical care from his child, and a modern-day adherent to an early Eastern religion could drown a virgin bride to appease a river god. So I just thought those were a couple of interesting comments. So here the child was not removed, but the parents were monitored and told to go to a class. The second case is Morrison versus State. It's a Kansas City Court of Appeals case. And they talk a lot, this case talks a lot about the parens patriae duties and what zealots have a right to do. And in this case, it was a transfusion case, and the court said a religious zealot may have the right to fast until death in the sincere belief that by doing so, God will be influenced to act positively on behalf of a sinful world, but he may not be permitted to abuse his parental authority by denying his children food freely offered by a compassionate society to relieve their suffering, preserve their lives and mental health, and also to get a blood transfusion when needed. In re Eric B. was a California Court of Appeals decision in 1987. And in this case, it was a faith healing case. And the child faced an appreciable risk of harm from a deadly disease, and that the medical testimony was uncontroverted. And because of that, the court said, that the risks were minimal. There was certain amount of physical discomfort, and this was a Christian Science case, but the court said, we're going to order the medical treatment. The next case is from Florida, JV versus State, and this again was a Jehovah's Witness blood transfusion case, and the court said that that they were permitted to intervene because the parents' action was motivated by sincere religious belief, and the court could order the transfusion. However, they can't be considered to have abused their children, and therefore the child should not have been adjudicated dependent. The court still had the ability to order the transfusion, and that was sufficient rather than to keep the child under the court's ongoing case. In Newmark versus Williams, a 1991 Supreme Court of Delaware case, this case said that the child was not neglected when the parents refused to have a radical form of chemotherapy, because in that case, while the state had a parens patriae right to intervene, this very radical treatment had only, quote, at best a 45% chance that the child would survive the treatment. And so the court said, no American court, even in the most egregious case, has ever authorized the state to remove a child from the loving, nurturing care of his parents and subject him over parental objection to an invasive regimen of treatment which offered only a 45% chance of survival. So you're looking at, how severe the treatment is, whether you have iatrogenic harm from just getting that treatment. And unless this is a fairly simple thing and the child is highly likely to do well, the court isn't going to intervene in that case. Cooper versus Wiley, a New York appellate court case. Again, the court said that because this was another Jehovah's Witness blood transfusion case, the parents, yes, the court could order the blood transfusion, but the court should not keep the family on the child abuse registry, because the child abuse registry was not meant for those sorts of people. And then the last two cases are the matter of Sean B.B., which was, the matter of Browning, which is a North Carolina case where the court said you couldn't, a father could not, based on his religious principles, prevent CPS from having a psychological evaluation done of the children. Supreme Court of Arkansas in Krantz, this was a Tony Alamo case where the mother was living in the community, even though Tony Alamo, who had molested several children, was in jail. She was still affiliated with the group, and therefore the court could say that she was, that was a termination of parental rights case. So because I'm in Texas, I just want to mention the FLDS case, where the Texas Supreme Court in 2008 overturned the removal of all of the children at the Yearning for Zion Ranch in a pretrial case. That case was ultimately dismissed. But the important thing about that case is the Texas Supreme Court case did not say that being in this polygamous community was okay and the state could not intervene. It just said you couldn't remove all of the kids, including the prepubescent girls and the boys, without a prior court order and an opportunity for a hearing. So that case has been pretty widely misunderstood. So, questions?
If you have a question, will you please come to the mic here?
I just wanted to know if you have the site for the FLDS case, or is it part of?
Yeah, it's in the materials, but it's 255 Southwest 3rd, 613.
Thank you.
Thank you so much. Can you say something more about, from your point of view, you said the law sees a person as a minor until the age of majority, and then they can decide. But if you were raised in a totalistic environment, what criteria would be necessary for someone to actually and pragmatically be able to decide if they want to leave it or stay in it?
Very, very difficult, and the courts have not been good about giving us guidance on that. And when you're talking about mind control and autonomy, I mean, that's a whole other situation. And by the way, when you're looking, even though there were 2 bricks on the parents' constitutional rights and only 1 on the parents' patriae duty, when you're looking at religion and the safety of the child is going to be, the weightier matter. Yes?
Oh, thank you. Do you have any court cases or precedents with Jehovah's Witnesses and their witness policy for reporting sexual abuse?
Okay, I don't off the top of my head have any cases for that, but and I didn't even get into the whole issue of reporting and failure to report and mandatory duty and criminal liability and tort liability, because I think that went beyond the scope of what this presentation was. But I think they're going to, well, they did just get what, a $28 million verdict for that, and I think that more people who have been victims of that institutional policy are going to follow what happened with the pedophile priests and file civil suits on that.
Thank you.
We have a question from Stacy. And where do you see a need for changes to America's legal system? Where do you see holes in it that need to be addressed to protect children from religiously motivated abuse?
Boy, that could be, a whole day. There are a lot of holes, and I think probably to give you the shortest answer as a child advocate, I would say giving children independent counsel is probably the biggest thing that we're doing. And many states do provide in child welfare cases for independent counsel to be appointed for the child, but some have withdrawn that because of fiscal problems. But I think that would, if kids are actually getting their own lawyers who are trained and know what they're talking about, I think that's probably the single, biggest thing that we can do.